Hey, everybody, and welcome back to the Legal Weekly Wine, where we discuss the week's hottest legal topics. And this week we are talking about Stormy Daniels' Stormy testimony. This is week 4 of the Trump trial, and we are following every week. And we cannot go without talking about, I think, the key witness. Everybody is saying it's Michael Cohen, but I think we turn that around this week. And it's Stormy Daniels. So we're going to talk about her testimony, what we think about it, how we think it affects each side, what we think about the attorney's performance for each side, and how the judge reacted to specific pieces, including the request for mistrial by the defense. So I'm Virginia Tehrani. I am the CEO of the Law Unscripted, which hosts this podcast, as well as the attorney owner for Tehrani Law LLC, because you never need a lawyer till you do. Now, I've been practicing for over 18 years. I am a trial attorney. Right now, I mostly do civil litigation, but I'm a former prosecutor as well as a criminal defense attorney, having done even murder trials. So I'm very excited about this week's podcast. I think it's definitely salacious. I don't think we've ever had a podcast that we've done that talks just about sex, and that's what we're going to do. So we are going to have a podcast about that. It is awkward, but that's what the whole testimony is, right? Yeah. All of it was awkward. All of it was cringe. I just, we're gonna walk through it because we have to. Chelsey Rogers is our associate with Tehrani Law. She's also an attorney and a trial litigator. Welcome and thanks for joining us.
Hey, I'm glad to be here. And the topic is, I didn't ever think we'd be having this conversation, but here we are.
Yeah, I think the judge thought that too. This has been quite the interesting testimony. And I've heard a lot in my years. I've heard a lot of crazy, interesting, cringy, salacious testimony, but this one tops it all. Dr. Vial. So on that note, we're going to say hi to you. Dr. Vial is a constitutional law expert as well as an expert in the Constitution itself, the amending process, constitutional convention, etc. So he has taught mock trial for decades, teaching aspiring lawyers how to do courtroom procedures. And I tell you, I think this is some of the things that we've seen in this week's trial are totally against everything you've taught, right?
Pretty much. And let me make just a brief footnote, or
please.
I don't know if it's a correction necessarily, but we did have a similar trial in your lifetime. And that
was not my trial, but sure.
Well, no, the Clinton years.
Oh.
Now, it wasn't a trial as such. Well, eventually there was an impeachment trial, but prior to the impeachment trial, there was an investigation that, among other things, produced a dress that had semen stains on it.
And the whole issue of the cigar?
And very graphic testimony about sex that he had apparently participated in. And so it's not the first sex scandal, certainly in our history.
No,
you know what's fascinating is there's an early case, probably nobody but me remembers, Alexander Hamilton.
I hope you don't remember it from personal reflection.
But, there's actually a fascinating case. When he was Secretary of the Treasury, it appears as though there was a husband and wife team in cahoots. Oh. And it appears that she seduced him, although he seemed to have been a willing victim. He was married at the time, and remained so. But subsequently, there was a rumor that he had paid off someone, or he had done something in connection with fraud at the National Bank, which he had established as Secretary of the Treasury. And he came back and said, no, it has nothing to do with the bank. This was a cover-up for an adulterous affair that I participated in. And he made something of a fool of himself, because, that wasn't exactly the kind of thing that would make you politically popular at that time. Maybe now it is.
Yeah, I mean,
I'm
the
not
beginning
sure.
of the country.
But he did think, I mean, in his favor, if you want to say that, is he considered public corruption to be worse, at least in that position, than moral turpitude on his part.
Interesting. And the case that you referenced before, the other awkward case in my lifetime,
Yes,
that's with
Clinton
President
case.
Bill Clinton, former President Bill Clinton, and the Monica Lewinsky scandal. One of
Exactly.
the interns, or whatever you called her, who was working
was
with
an
him
intern.
in the
That's
White
right.
House. And
Yes.
who was the one who was on the phone and recorded all of her phone
Oh,
calls?
yeah, Linda Tripp.
There it is, Linda
who
Tripp.
was something of a trip.
Yes.
I mean, your best friend, she was her best friend until she got the recording that she could then release to the world as to their conversation.
Yeah. So no, you're right. So that was pretty crazy, a little stormy.
It was.
But yeah, oh my goodness, it was terrible. National news, national coverage over a huge sex scandal involving a president who was still president at the time.
Yes.
So this week we finally did turn to Stormy Daniels, who was put on the stand, and the prosecution called her. And as I understand, I don't know if she presently is, or at least was a former porn star. Definitely one during the time period that we're talking about where she allegedly had an affair, whether consensual or not, which is an interesting piece of the testimony, with Donald Trump. And that was around 2016. Before or did she alert everybody at 2016? I can't remember when it actually occurred.
And I think there's actually, two people involved here, one of whom is not going to be called.
Correct.
Karen McDougal, as I understand it, a Playboy bunny, whatever, was apparently, and again, I'm not saying this necessarily for the truth of the matter, but I think there seems to be evidence that she was actually in a longer term relationship with Trump. There doesn't appear to be much of a relationship here other than, I mean, it basically sounds
affair.
like sort of a one night stand, motivated perhaps in part by Daniels thinking that she might get an appearance on Celebrity Apprentice.
Oh, that's right.
Celebrity
The Apprentice.
appearance. Right.
Yeah, the affair
so-
was in 2006. So that's when they slept together. So
And she was going to then release it
in
in
2016.
2016 during the
and
campaign.
actually what Chelsey says is contested.
Right.
And the reason, and here's arguably a mistake. If Trump had just, and of course, if he didn't do it, he can't admit to it. But if he did it and had admitted to it, much of today's testimony or yesterday's testimony would not have come into play.
Exactly.
But because he says, in fact, I think at one point, I think he's denied even knowing who she is.
Right.
Which doesn't work out too well because it turns out there are pictures of her and there are other people who are testifying that he met with her. But had he not denied the allegation, then there would be no need for her to go into the details.
Right.
And apparently this has been true of much of the trial. And for Virginia, you and Chelsey both are going to know this better than I do, but typically in a trial to expedite things and sometimes to avoid embarrassment,
yes,
you would just say, well, we will stipulate that the two, met or that the two had a relationship or, one night stand, whatever.
Make it as minimal as possible.
Right.
Get it away from the jury.
And I mean, the irony of this case is it really doesn't have to do with sex.
Exactly.
In terms of what the charges are. The charges, as I understand them, are that he made a payout and then fraudulently indicated what the documents are for.
Right.
And so, but if he had just, and again, to go to what Chelsey said and to repeat the comment that I made a week or so ago when Romney said, it's pretty unusual to pay somebody $130,000 not to have sex with you. And the fact that he apparently has made those payments does seem to confirm her story. What's happened this week is the attorneys for Trump, probably to please him, tried to basically call Daniels' integrity into question. And I think to some degree they succeeded in. I mean, I don't know about my wife and I were talking, a day or two ago. I said, well, how many porn stars do you think I've, invited over to the house for conversation, or had dinner with? I mean,
I hope the answer is 0.
Well, that was the answer, right? That was her guess, and she was correct. But the sleazier his attorneys made her, and there's a lot there. I mean, I don't know if I can use this word, but, she was on a tour to make America, can I say it?
Yes, say
horny
it
again, right? I mean, that was, she has profited from this, but the sleazier she looks, the more you wonder, well, what in the world is this guy hanging out with her for?
Right. The worse he looks for it, too.
Why else would you hang out with someone like that? It's
right.
sort of
the only way
question.
She doesn't seem to mind, but the way that she's known is for being a porn star. That's the way she's made her career.
Apparently.
Exactly.
Yeah, director and producer.
Right.
I think she changed her name officially to Stormy Daniels. This is a porn star name. Right. This is the way she's made her career. She's made her life. This is the way she is known. And I think, it rings true to me that she met Trump and would have had a sexual relationship with him in order to get on Celebrity Apprentice, because it was really big at that time. I mean, you had Meatloaf on there. You had Busey on there. You had Janet Jackson was on there. I mean, there were so many real celebrities, and she is a celebrity within a certain piece.
And this, by the way, is why a lot of political scientists, including myself, were clueless about Trump prior to 2015. Everybody watched him on television every week. I never watched, maybe saw 10 minutes of a program one time. Mm-hmm. But apparently, it presented him as, a wealthy decision maker. Yes. And that was what a lot of people wanted at the time.
Cutthroat decision maker, cutthroat businessman is what he was portrayed as.
Apparently, the evidence is that he really doesn't like firing people, that he usually gets an assistant to do it for him, which I can understand. That's not a pleasant part of a job, at least for most people, it's not.
Right. And, I think it does ring true. So Chelsey, I'm going to stick with you with explaining what testimony actually got in. And if you're uncomfortable with it, I understand. But go for it if you can.
Look, let's talk about it. Okay. So one, I will just say to begin with, I was shocked that we were even getting here, right? Like as Dr. Vile said, it seems fairly irrelevant to the charges at hand, right? Like he's not debating whether or not he paid her the money, right? He's just sort of getting into this conversation of what it's about. But I do think it's been interesting. I thought it was interesting on direct. So, we have the prosecutor talking to Stormy Daniels. I think she did a decent job at trying to rehabilitate as best as you can sort of her career. I saw some reporting on it talking about one of the things the jurors were never asked about are their feelings towards sex work or adult films. And so that's really interesting that now we don't really know how it's going to play with this type of jury. So I think that's interesting. And I do think the prosecutor did as good of a job as you can do at putting the focus more on her production, directing versus maybe her acting career in this field.
Right. And
essentially
she testified to over 200 films.
Yeah, I mean, right.
And by the way, she said she wasn't acting.
Well, right. The
sex is real, right?
Yes.
And I think this is just my commentary. So, okay, we can go through it. So they're on direct, the prosecutor tries to really focus away from her acting in these films and sort of the rest of her resume. But then we go on and we're like, okay, what happened? This is the night. This is the incident. How did everything play out? The long and short of it is essentially they were at a hotel. He invited her to have dinner with him. And then she showed up to his hotel room and he was not in dinner clothes. Okay,
Right.
This isn't fun. It's not funny.
It's uncomfortable, right?
No,
it's
because
hard to talk about.
I don't think it's okay. This is all I can think about it though, because she's like talking about him in these pajamas, which I don't know. Maybe it's just me. That is hysterical. The thought of picturing any former president in silky pajamas, like I would not pay attention to anything that came after that. That's what I would be thinking about, and I don't really know.
And you'd be picturing him while he's sitting there in the pajamas,
right? And I'm like, I would have lost it at that point. You have my ADHD would have taken me out, and that's all I would have been thinking about going forward, because that is objectively hysterical. Like I want one of those like old timey cartoon court sketches of that. Actually, I think it would be beautiful. So we go through, then she's like, we had sex. Well, they had dinner and then they had sex. And
maybe they had dinner.
That
seemed to be a critical question by the defense as to whether they actually had dinner or they didn't have dinner.
Right. Yeah. At least that's what sort of the story that the prosecutor pulled out of Stormy Daniels was. And yeah, that's the long and short of it. I really didn't I will say this. When we had the defense crossing, I didn't think she made a good point on this part. She kept trying to be like, oh, well, you produced these films where you're making up stories about sex and trying to draw this like parallel to this scenario.
That she's lying to show that she's acting and lying.
And I think it was not effective. And I think it was kind of poorly done. Like, I don't think she was making the point she thought she was making. Sort of in that line of questioning, you can make the point that she's lying. I don't think by comparing it to sort of producing or directing films of any sort, that it's really drawing that parallel.
Well, it's hard because I think any actor who takes a stand in whatever film industry is always questioned of, hey, you're an actor. You know how to lie. You know how to put on a show, to make an appearance. Mm-hmm. And I think in some ways that was effective. But she really shut them down. She was a powerhouse. She had a response. I mean, she looked seemed a little snippy, but at the same time, she seemed completely herself.
Yeah. And
her character, whether it's real or put on, was consistent throughout all the testimony. And in mock trial, for real trials, how lawyers work things, your best witnesses are the ones who are the same people with the same types of responses from direct to cross. And I think she did that.
I agree. I think sort of the tonal vibe, the vibes are the same.
There's Chelsey and her vibes.
What would be interesting in this case, of course, we don't know, we're expecting Cohen next. He's the one who's allegedly paid and then got paid back for this.
Right. With interest.
But it seems like maybe one of the most effective defense witnesses that you could use is the doorman. Because, what apparently happened there is he was leaking a story that Trump had fathered, I believe, an illegitimate child.
Correct.
And it turns out, apparently, that the story was not true.
He just wanted money.
But that he paid him anyway. And I mean, that could be a pretty good argument. Yeah, it's sad to say, I have had to pay people for stories that are untrue.
Because they look so bad in the public.
I mean, it just, again, to go back to the Romney quote, it just makes it so hard to believe that you would pay for something that didn't happen.
Right.
And by the way, well, again, I don't say this from experience, but that seems a pretty high payment to a prostitute.
Right. And she's saying I wasn't, but her presentation is that she's very promiscuous. That seems to be the presentation that's happening. And it was a risky move for the prosecution. is, ultimately, Chelsey, I'm going to go back to something you were saying is, did they even need her?
That's what I'm saying. Okay, this is, me Monday morning quarterbacking, right? But here's the thing. I feel like this took it where this shouldn't have gone. We said this from the beginning. This is a boring business fraud criminal trial. That's what it should be. We're already having issues with the defendant speaking in public, talking about the witnesses. Again, I'm a baby attorney. I just like talking about things, so I don't know. But to me, it seems a little foolish to bring this back into the sensational parts of it that aren't particularly relevant to the question at hand, right? And so I'm just frustrated, I feel like, because why are we doing this again? Why are we bringing it back? Who is this benefiting? Because I can't see how it's benefiting the prosecution all that much.
Let me give one.
Okay.
Yeah, please, because I have some thoughts too.
What did we say? Fourth week? So
Yes,
fourth or third?
fourth.
Yes.
It's week 4.
4 weeks listening to people dissect documents.
Yeah.
Is going to be hard to stay awake.
Right.
And there does seem to be a certain strategy. I mean, you don't start off with your most salacious witness. You don't. Right. I'm not sure I don't know if they'll end with Cohen.
They started off with a pretty salacious one. Didn't they start with the National Enquirer president? And that was...
Yeah, I mean...
Not Stormy
salacious
Daniels.
In terms of business practices.
Mm-hmm. Right.
But again, there doesn't seem to be... And in contrast to... It does seem like many of the jurors, from what I'm hearing, haven't even cracked a smile. I think there was one report once that one of them was trying to suppress a laugh about something.
They're responding.
But, pardon?
They're responding. They're physically responding to the testimony.
But it sounds like they really are trying to, I mean, I would find it hard to listen to accountants very long.
Right.
I would just tune them out. And you notice they followed Daniels with 2 or 3, paralegal. I mean, sort of routinize legal kind of, did you take this letter? Did you see this, take this phone call? Did you see this letter? Is this how he signs? And so in terms of giving the jury something to maintain interest, give them to talk about when they get to, it's certainly done that.
Well, and to me, so first of all, we have to do the wine. We haven't done the wine, but
we just had to jump in. I mean, look.
I have got a 19 Crimes wine. I thought it was appropriate for today's podcast. Dr. Violet, looks like you have a Coke. You must not have gotten that from the campus vending machines.
I did not. The wife sent that with me today. Yes.
And Chelsey, you've got some kind of white.
Yes, I'm back at it with the Moscato. Nobody's surprised. We know I like my sugary sweet wines.
Yeah, well, these 19 Crime wines, those are really fun. We've had a lot of them on this show, and it's a label. And today it's the 2021 Shiraz, and they have it's about Australia and the 19 crimes that would get someone sent to Australia, and they have actual stories on them on the back of the bottles, and some have QR codes that you can actually look up. They even have one, my favorite ones there's one for Snoop Dogg and for Martha Stewart. The Snoop Dogg one is actually really good. But anyway, so that's the wine we're drinking. Cheers. And then I'm going to talk a little bit about the testimony.
And not to bring up some unhappy history here for Chelsey, but what state was largely settled? By
Georgia.
By prisoners.
I know. I'm not surprised. It makes a lot of sense. I think the only state that would, be more fitting at this point was if it was like Florida. There's always some wild story about Florida man does whatever. But Georgia's pretty close. I'm pretty close.
Yeah. So
it could happen anywhere.
Yes.
So let's talk, Virginia. There was one line I really wanted to get in today.
Oh, please. And I have so many. I'm
and let's
so
see if
excited about this.
But you need to sort of set me up for it. Because we were talking about the judges. Tell a little bit about what the judge said.
Oh, my heavens.
To to Trump's counsel.
I am so excited about this because I am on the edge of my seat with this week.
You wouldn't be if you were on the receiving end of it.
No, oh my goodness. Yes. I would just crawl under a table and die, because what's happening, as a little intro to it for those who haven't followed it fully, is in presenting this Stormy Daniels testimony, there was not really an objection, much of any objection at all from the defense. They let the testimony in. So
during the prosecution direct.
Exactly. Right. So the prosecution went through, I would have done the same thing, is tested it. How far can I get? What can I get out? And if no one's objecting, I'm thrilled. And that's what happened.
I think the judge at one point objected. Am I not right?
Well, he didn't object.
Didn't he say you're going a little bit too far here? This is, beyond what we need.
Yes. So we get to the point where the defense moved for a mistrial based on Stormy Daniels' testimony. They were arguing that, quote, the guardrails were thrown aside and that her testimony was so unduly prejudicial to Trump that he could not receive a fair trial. It's a great argument. Her testimony, Chelsey, as you've said, is really irrelevant. It's, did you have sex with President Trump? Yes or no? Did you get paid? Who paid you? Right. When did they pay you?
Not what position were you having sex in?
No. The relevant questions relate to the monetary deal that she cut with President Trump during the year of the election campaign. That's what's relevant.
You told me that you wondered if Trump might be able to
get a new trial.
An appeal on the basis of
ineffective assistance of counsel.
And I said,
truly, okay, hold on, because truly for everybody, if you don't object to this, it is, trial advocacy 101.
Use it or lose it.
You have to object, and if you don't object, you lose any possibility of going forward. So by making a mistrial, a move for a mistrial, the judge appropriately was saying, well, you can't because you never objected. And Dr. Vial, here you go. What's your response?
Okay, so you said, maybe Trump should file a suit for ineffective assistance of counsel.
Put it up on appeal.
I said a better appeal might be ineffective assistance of client. That it appears as though the client is the one who really wanted to embarrass and denigrate Stormy Daniels, and that's basically what he instructed his attorneys to do. And that his attempt. I mean, she does it. The other thing that came out in the trial that I think I have a different view than most people. Most people thought that it was a major concession when they said, you really hate Trump, don't you? And you would like for him to go to jail. And I think the fact that she said, yes, I do hate him, and yes, I want him to get his comeuppance, or whatever. I don't think she said jail. She wants him to receive justice. I think that actually lends to credibility. I think if she said, "Oh no, we're still best buddies," nobody would have believed it.
Right. Yes.
And I'm not sure, given the interactions that they've had, that she would even be able to say, "Well, I really don't have an opinion one way or another." I think she despises him.
Exactly.
And I think just forthrightly saying, I don't like the man. I'm going to tell you the truth.
Exactly.
I think that was pretty effective.
Yeah, I agree. And it's interesting, and this is why I say she was just as effective during cross, is during cross, she said, this is really fun. Oh my goodness, there's some really, I can't say half of this. Some of this is really nasty. But she had a part where oh my goodness, where is this thing? I thought I had said it. Or I had saved it. But basically the defense attorney was saying, well, you said this in social media. And she said, no, I didn't. Where did you find that?
It was about her Twitter.
Yes.
It was about something she tweeted out, and she misquoted it. It was
completely completely
attorney had
misquoted.
misquoted,
Exactly.
right?
Sorry,
Or
yes.
misinterpreted it.
Yes,
Yeah.
and she says those weren't the word. Oh, here it is. Show me where I said. Okay. The attorney asked, isn't it a fact that you keep posting on social media how you're going to be instrumental in putting President Trump in jail? So, Dr. Weil, this goes to you. And Daniel says, show me where I said I would be instrumental in putting President Trump in jail. And she entered a response, the defense attorney, where Daniels had put a social post that referred, let's see, she was the best person to flush Trump down,
Yes.
is what her comment was. And she
It was
says,
actually more explicit than that.
I'm doing my best
Let's
to
go with your version.
Those words were in there.
Yes.
And Daniel says, I don't see instrumental or jail in there. You're putting words in my mouth. And so I think she really did prove credibility there, where she's saying, that's not what I said. And sure enough, what the defense tries to put in doesn't say anything like that. So I agree. I think she came off fairly credible. And any attempts that Trump thought he had, or the defense thought they had, either with or without his agreement, to portray her as this horrible person, have backfired. I think she came off, maybe people don't like her, they don't like what she does, but she came off as very truthful. And the other really damaging piece is, by the end, you weren't sure it was consensual. Right? Chelsey, I see you wanting to talk here.
I don't know if I have much to add, but just kind of highlighting that. And yep, I think that, your takeaway from it was very similar to mine, of that I think it's very clear. I believe her about how this all went down. I think the fact that we're fighting over this at this point in this case is a little silly, just on the legal side of things. I think it's distracting.
Yes.
But then we start talking about like how that all played out. And I was like, this feels like another crime, actually.
Yes.
Well,
exactly.
To put a finer point on it, it would be closer to it would be almost closer to what we would call sexual harassment than it would rape, as she described.
At least some kind of
she mentioned specifically a power imbalance.
Yes.
And if I'm understanding, there's a guard outside the door, a bodyguard outside the door.
Correct.
And so I don't think she was alleging non-consensual sex so much as she was saying, I was put in an unexpected situation and didn't, much as in a hostile environment at work. And possibly, if we want to go with that analogy, you also have the quid pro quo aspect. If she thought this was facilitating in some way the chance that she would have to be on The Apprentice, then that would have been there too.
Absolutely.
But it got a little uglier maybe than one anticipated prior to coming in.
It really did. And the jury, this is, I'm so excited about this. I don't know where to go first or next. And the jury, for the prosecutor, I don't know who this is going to backfire on. I don't. Because now if the jury is thinking, well, he coerced her or raped her, however the jury is perceiving this testimony, if they believe her and now believe not only did he have an affair, but he might have done it, in a criminal fashion, then that is making Trump look bad, and it's making him look worse, and it's setting them up. And this is why it could be unfairly prejudicial to the defendant, where if they think he committed one crime, then they're going to assume he committed the other. Okay, it's financial, but of course.
Let me add two things here. One is I want to go back to, one is none of the three of us have been in the courtroom.
Not Trump's courtroom, correct.
And most of the commentators you hear at night have not been there either.
Correct.
And so we're getting not quite hearsay, because we got reporters and whatever that are in there, but we have no idea emotionally what these jurors are thinking,
Exactly.
for better or worse. And so there is, those who think that the fix is in, I think really don't know how juries operate.
Absolutely.
Based on what I've heard, I would be willing to accept as legitimate either decision that a jury would make based on what they've heard so far.
Yes.
Particularly as regards the underlying crime. So I want to start there.
Yeah.
The other thing, though, that I found interesting, because it blends into what I believe was our last podcast, I had raised an issue that I don't think we resolved, which is, why is it that there's not a gag order against Cohen? Why is it,
or Stormy Daniels?
I can see why Trump should not be able to slander a juror or go after family members of a judge. But if Cohen is out there calling him a liar, why can't he call him a liar back? And what I've discovered this morning is apparently that the judge has issued instructions. I don't know if it's an order, but to the prosecutors, that they're to tell Cohen to lay off at least until his testimony is done.
Right.
And
that
so
was
that's
what
sort
I
of
was
an
suggesting
interesting
last
week.
week.
I mean, that seems fair to me, that if you're going to censor one side, and then the other thing is, and I think I heard you guys wobbling on your prediction, and I may wobble on mine, because you two have claimed that you think Trump is going to testify, and I said I don't think he will, but I'm going to waver a little. Stormy Daniels sort of threw down the gauntlet after the trial, and basically said, if you're a man, you'll get on the stand and you be cross-examined like I was.
Exactly. And I think
that's
the
what I'm
prosecution
saying. I think he's going to testify because he cannot control himself, and they're making him mad. And I think by the time we get to the end of the prosecution's case, he is going to be chomping at the bit to get up on the stand and have his soliloquy, have his moment.
But am I right? Neither of you would advise him to do that, right?
Oh, goodness. I would be on my knees
not.
begging him not to.
Yes.
I would
withdraw as counsel at that point.
Right. I mean, you write him a CYA letter. You write him a letter that says, I have advised you not to do this. You were doing this against my advice. And you put it in your file. So when the bar counsel comes calling at you of an ethical complaint, you have, no, I told him not to. Here's my advice. But it's interesting because we're talking about Trump's reaction. And during Stormy Daniels' testimony, he started cursing. He was audibly cursing. And the judge even called his counsel up and said, I understand your client is upset at this point, but he's cursing audibly and he's shaking his head visually, and that's contemptuous. It has the potential to intimidate the witness, and the jury can see that. So he admonished him to go back and tell his client, former President Trump, to stop cursing and audibly making responses. But I think they're poking the bear. And I think it's working, and he is visibly and audibly getting angry. And to go back to your point, Dr. Weil, about, the gag orders and why isn't there a gag order against some of the prosecution witnesses, I think the ultimate issue here, and the judge goes into this even later with the possible prejudice of Stormy Daniels' testimony that I do want to come back to, because he says this prejudice, there is prejudice, but the question is an intimidation of witnesses and jurors. So the prosecution witnesses don't seem to be intimidating other witnesses or jurors. You could say it's possibly for Trump, but Trump's never going to be intimidated by one of these witnesses. He's going to speak up more loudly rather than be intimidated, which is what he's wanting to do. But the protection of the legal process has to be one where the jury's protected and where the witnesses aren't discouraged from or afraid to tell their story. And that's why he has the gag order, is because the judge is trying to protect the process of justice, to make sure no one is improperly intimidated. I go back to my gang example. I'm not saying Trump is in a gang. It's an analogy of a gang member is put on trial. The potential for intimidation of witnesses is strong. So if a witness wants to go and say anything in the, out in public, they're the ones putting themselves on display and at risk. The question is the defendant or the gang that he's a part of intimidating the witnesses so they don't appear? Getting rid of the witnesses so they don't appear. And I'm not saying Trump would do that, but clearly the judge is very concerned about even his actions in the courtroom being perceived as a power play, as intimidation, something in front of the jury.
But if you were on and I think that's well taken, but I wonder if it may be, again, one of those things where the judge is actually protecting Trump.
Yes.
More he protests.
Agreed.
I mean, if I were a juror and I saw somebody cursing there, I wouldn't necessarily say, well, that's a good man trying to protect himself. I think, the chickens have come home to roost. So,
yes.
Again,
I
that's
think
why
that's true.
When you love to be, they ought to put a political scientist on each jury, and you can't do anything. You just sit there and try to record your own reactions.
They should film it. Look, this is what we did. This is my, my suggestion for improving the judicial process. This is what, thank God for technology, we did for all of the juries for like the mock trials that I did during law school. They were all recorded. And one of them was actually live. So it was like live feeding into the room with all the people who participated in the trial. That was crazy. One of the most fun experiences, because they just put up this camera in the side of the room and we're watching them live debate on the outcome. Crazy. But all of them were like recorded jury deliberations. So we kind of got an insight into like what people were thinking. Crazy.
Yeah. And so I want to go back to the judge, because this is him talking. Defense counsel, as we've stated, asked for mistrial, I believe twice, saying that Stormy Daniels' testimony was so prejudicial that the jury wouldn't be able to get beyond it to see the facts of the case, which are fairly mundane, but still possibly criminal. And the defense attorney argued there were a whole host of questions that never should have been asked, things that are irrelevant of the case. And then the judge said, well, you told the jury in the opening statement that Trump was denying any sexual encounter with Daniels. Right. So you put it at issue. And because you put it
open the door.
You opened the door, and because you claimed this in your opening statement, the prosecution has the ability to put her on the stand to admit or deny the statements that they slept together. And the judge says your denial puts the jury in a position to decide who to believe. So they put it there, and then this is the funniest part for me. As a trial attorney, where the judge actually said to some of the details, he said he agreed they shouldn't have come out, but for the life of me, I don't know why you didn't object.
Embarrassing.
Died.
We keep talking about this. I feel like in a lot of Trump's cases where things happen and it like are my nightmares. Like, these are the bad dreams I have when I think, I like, as a new baby attorney, and you like dream about things, stress dreams, that a judge saying that to me, that's what's happening in my nightmares. That exact thing, because that is.
Yeah, you can't.
And if I remember, Trump was sort of prodding his attorneys to object more.
I think he was.
But sometimes, right, when you object, then jurors are going to think, why don't you want that in here?
Yeah.
So, I mean, it's not as easy as just, if I object, it's going to keep it out. It might underline it.
Right. And that's the question, is if there's an appeal based on ineffective assistance of counsel, the response very well would have to be, it was trial strategy. We intentionally didn't object. We had these reasons. Now, it may have been a horrible reason, and it may have played horribly wrong. But if they can show they had a reason that was reasonable, then it wouldn't be ineffective assistance. I think it was. I think these were very poor decisions not to object to almost all of the testimony and to get it in, especially as underlined by the judge. If even the judge is thinking you should have objected. And he said, I can't give you a mistrial because you didn't object. If you don't object, you don't preserve the issue. You don't preserve the objection to say something bad happened in this trial that's against the rules of evidence and against my client. It harmed my client, and therefore there should be a mistrial or there should be an appeal because something bad happened that harmed my client. But if you don't object, you can't say it harmed your client. Right.
You were in the courtroom as it was happening and you did not try to stop it.
Yeah. He's and I can't pronounce the name. I apologize. Nechelles, is that how you pronounce the female defense attorney? Nechelles. I'm doing my best, but this is a very salacious part of it. But the judge specifically faulted her, saying she should have objected when prosecutors elicited testimony about Trump allegedly not even using a condom. He said, I wish those questions hadn't been asked, but for the life of me, and here's that comment, but for the life of me, I don't know why Mrs. Nechelles didn't object. Why on earth she wouldn't object to the mention of a condom, I don't understand. Right. And I think that's correct. It's irrelevant and extremely prejudicial. And this is when we get to 404A and 404B. Now, I don't know the evidentiary rules in New York. Most rules in any state courts follow fairly closely the federal rules of evidence. Not all of them, but fairly closely. We all do know the federal rules of evidence, and I am certain that there is a state correlative rule for what we know as 404A and the federal rule of evidence 404B. Which is, bad acts. It's considered the bad acts statutes. Dr. Weil, do you remember, I know in all your years of mock trial.
Prior bad acts, right?
Yes, correct.
You can't use prior bad acts unless, there's a little exception, right? Unless they actually show it's not a proclivity, but a pattern.
Yeah, there's
like
a pattern of behavior.
Like an MO, like a...
Right. I mean, if it were common for him to sleep with people other than his wife and pay hush money payments, then you could probably get that in.
Right.
If it's a one and done or whatever, then probably not.
Right, where you can't get in a prior bad act. So it doesn't have to be a criminal act. It could be. Right. But it could be just something that was bad that the defendant did, and you can't get it in for propensity, which is for the proclivity, like you said, whether the defendant is more likely than not to do this behavior. You can't show that because he did one thing bad, he necessarily did something else bad, which is the prejudicial effect. You can get it in, like you said, for modus operandi, the MO, for intent, for identity, that sort of thing. But on the whole, you're prevented from bringing up bad conduct of a defendant because it is so prejudicial. I wouldn't want people to say the things that I've done before. Any of us. I mean, think of some of your worst conduct and behavior. Would you want somebody to put that in trial? If you're not even on trial, I mean, you wouldn't want it anyway, but especially if you're not on trial for that particular thing. Even drunk drivers, you wouldn't want it put in that you were a drunk driver or convicted of one when you're talking about financial settlements for the purpose of, quashing campaign stories. It's similar. So I think they really dropped the ball, the defense did, in not objecting to all of this, because I think it could have, almost all of the testimony could have been kept out. And honestly, they should have done a motion in limine.
To what extent, now, Chelsey sort of indicated, maybe it was you, indicated that you thought maybe the prosecution was goading Trump through this testimony, but is it possible that they didn't have that much control over Stormy Daniels either? She went far beyond what I would have instructed her, I think. Just answer the question, did you have sex with Trump? Yes. You don't need to go into the how. The only reason to go into the how would be, and I think some of this did come across, that it could be a made up story, but it sounds like she authentically remembered. So he's denying that it happened. Well, not only did it happen, but there was a parquet floor there, or the drapes were, red or whatever they
Right.
were, that somebody could come back and say, well, there is no such room there in that motel. So, but don't you think she probably she probably offered more testimony than the prosecution asked for, or not?
Chelsey,
Oh,
it's
for
all
sure.
you.
Okay. Oh, for sure. But this is why direct is hard, is because you're supposed to
Yes.
just ask such a basic question and then let them
Right.
say what they're going to say. Virginia has told me this every time we talk about this. She's like, Chelsey, you'd be a terrible witness, which is true. Because you would ask me one question and I'd be like, actually, I have so much to say about that. We watch this happen
Well,
on the podcast every week.
You would not be nearly as bad as Virginia's mother in that regard.
So true.
Okay?
It's so true. Bless her heart. She's an amazing woman, but she would be my worst nightmare of a witness. You second,
Right.
but my mom first, because she would want to tell you about it all. Well,
Yeah.
Grandma said this about Auntie Anne, and then Auntie Anne had a little boy named Busty, and Busty
And that made me
talked
think
about
of
Jane,
this.
and then that's how I came to this conclusion. What?
Yeah.
Really?
I think my inability to tell anything in chronological order would be my real downfall, because I'd be like, oh, yeah. But then, before that. But that's the hard part, right? Is that if you are asking, and this actually happened during multiple of my fake trials, and these are with people who are my friends who would play the witnesses for these very closed universe fake trials. You would practice and practice and practice. And you would, because in this scenario, they're learning the facts. They're memorizing essentially this thing. And then you would get to the day of the trial and they would say something. And you're like, where could that have possibly come from? So we had this happened in one of my fake trials, is that I directed this person as a witness. It was very simple. There were 3 facts that were relevant in this closed universe, but they changed a wording on something. And so the case was about whether or not, it was a self-defense case of whether or not this kid was in a gang, right? And so my witness was supposed to be this old man in the neighborhood who was like, oh, I call this kid by this nickname. It's not a gang name. I call him by this. The person I was working with got up on the stand and said, I gave him this nickname, which is a very different thing. Okay. Which is a very different thing. He didn't mean to. We just get to the point where he's, sitting in this witness stand and he's being asked, and he said, I gave him this nickname.
And there it
everybody
is.
in the room is like, what do you do? What do you do?
Yeah. I had one of my favorite instances of that is your witness gets away from you, even on direct. I mean, I had worked with her beforehand. It was a rape case. She was the victim. And ultimately, the man was found guilty. But I tell you, you could have knocked me over. And, you have to, as a trial attorney, you really have to practice the face, right? You can't react and respond to the things that come out of people's mouths. You have to have a solemn face. You have to act as if you're prepared for anything that's happened. And it was, my face was put to the ultimate test of what am I going to do with this response? Because we were talking about how she and her boyfriend and this other man who was the defendant were all in a room hanging out beforehand. Then they left, and then the one came back, and it proceeded from there. But all of a sudden, after having practiced the testimony and said, here are the questions that I'm going to ask, she's like, yeah, we were hanging out. I had 6 blunts and drank this much of the vodka. And all I wanted to do was die, because who knew? I didn't expect that. She hadn't told me that before. And I mean, clearly she was very honest. And in the end, at the end of the trial, the judge was so funny because it was a bench trial. And he specifically said, honestly, I really believed the victim because she even admitted how much she drank. No one would admit that if they hadn't drunk it. So it became a key to her credibility. But at the time that it was coming out, it was quite shocking and unexpected from even a direct witness that I had put on.
I wonder if, I also think about this because they talk about this trial strategy wise, in law school, that maybe the prosecutor was just like, hey, I'm going to get up there. I know how she talks. I know how it is, but it's better that she's like this when I'm asking her questions. And then she's going to be the same way on cross, that it does sort of go to that like authentic, right? Like,
yeah,
because
good luck,
I think about
defense attorney.
All I can do is think about my own personality. And if I tried to keep my direct answers to very, very small direct answers and then got on cross-examination, I would seem mean because I would be combative instantly. And so I just think about maybe there are more people like that if you don't let them be themselves during direct, you're definitely going to see it in cross, and it's going to be a problem.
Well, and that's why I think, honestly, a motion in limine should have been done. And for those of you who don't know, these are motions before trial that are held with the judge between the parties to say there's a specific piece of evidence that should or should not, most commonly should not come in. And here's the evidence. Here's why I don't think it comes in. And I'm asking the judge to rule before the trial even starts in favor of or against the information.
Would you have thought about those details? Would you have
absolutely.
Thought
because
you would have.
I mean, I wouldn't have known all the really specific details about the night clothes, et cetera. But what I would have done is, Stormy, okay, let's think about it from defense view, right? Stormy Daniels is a witness. She's a porn star. It's going to be bad. She's going to try to cast it in a bad light. She's going to try to talk about the sexual encounter. And if she doesn't, I don't want her to. But there's such a high risk, even before the trial, even before her testimony, that she would go into more detail about the affair. There's such a high risk that she might cast it in a light that's already unfavorable, but even more unfavorable. And that whatever she says could be so inflammatory that you don't want her to say it. So I'd say, we don't know exactly where her testimony is going to go, but we know it's very possible, if not probable, that there's testimony or information or facts concerning the actual incident. And we're asking for that to be excluded.
I was going to say, I think the thing is that I have a really hard time with this, and maybe I'm just not understanding something, but I'm like, I don't understand how any of her testimony is relevant to the case at hand, right? Like the idea of, we know it's going to be so highly prejudicial, and I don't think it has any probative value. That's sort of the balancing scales we're supposed to use.
403. Rule 403.
And I'm so confused at what the probative value in her testimony is to the crimes we're talking about, right?
So,
like she doesn't offer anything about his mental, like him going in of like, oh no, my wife is going to be embarrassed, or oh no, I want to steal an election. She can't speak to that. She can't speak to the business accounting. So I'm really confused on like what the purpose of this was, why she was allowed to testify.
So to go back to the question of Trump, to go back to the question of jurors and what they're thinking, is there a chance that Trump is more believable in denying this affair by the very fact that he knew salacious details were likely to come out, and he's still saying, I'm going to fight it? I mean, is that possible, that even after all this embarrassment, he's still saying he didn't do it? Maybe he really did. Maybe she did make it up.
He could say that, but here's the thought.
Could they be thinking it? That's what I'm asking. Could the jurors say the very fact that he was willing to, he knew this was a possibility, he still let it, maybe he didn't, maybe it wasn't as salacious as suggested. I don't know.
I think Hope Hicks' testimony goes against this. And here's where I'm going to tie her back in. Because I think all three of us believe that she was a very credible witness, who used to be very favorable toward Trump, and seems to have been caught up in the middle of this. And a piece of testimony that I thought from her might be very favorable for the defense was how she said, well, he told us at that time he really didn't want his wife to know about the information, that he didn't want her to see it. That spoke to intent, right? Where she's talking about, so his intent in trying to hide this story, in hushing it, covering it up, would be so his wife doesn't hear about it. So that does speak to intent versus Stormy Daniels, but I think it actually now hurts the defense in this way, Dr. Vial, in speaking to your thought. where if they're thinking about it and putting it together and being, active listeners, I would go back as a juror to say, okay, well, is it true? Well, Hope Hicks said that he didn't want his wife to hear about it. Hope Hicks didn't say, well, he said that's not true. I don't want an untrue story to come out. Hope Hicks said he didn't want it to come out because he didn't want his wife to know. Well, that to me sounds like an admission. So maybe she's, exaggerating a few facts, but in the end, as a juror, I think I would believe that some kind of sexual act had happened. Most likely actual intercourse. Now, whether it was all the parquet and the pajamas, I don't know. But as much as has happened, and as many other people who have testified, and if the prosecution gets in, and Dr. Vial, you were saying that the doorman might be a great defense witness because he was lying, and they were paying him to hush up the story. In a way, I think it also would go toward the prosecution, though, because people figured out he was lying. They could disprove his story, but nobody's come out but Trump to say she's lying. He's the only one out there saying she's lying. So I don't think it's that credible for him to say, I didn't do it. It would be more credible in my mind for him to say, yeah, we had sex, we had an affair, it was a one-night stand, it was no big deal, and move on. And then just continue to deny the rest of how she's saying it occurred.
Yes. I think that would make me change my opinion. That type of testimony of saying, yes, this happened, but yes, I'm a bad person, I cheated on my wife sort of thing, but I didn't do all of these other things would make me change my opinion. But I think, I don't know. I don't know if the jurors feel the way. And I think that's goes back to what Dr. Vial was saying of I think this is someone who is so used to being able to talk themselves out of situations, whether or not what they personally are saying is true, right? So I see his continued denial as just the same behavior we've seen for a lot of years at this point of someone who continually just thinks they can talk their way out of everything.
So what I'd like to know as a political scientist is there anybody on that jury, however they decide, who would still vote for Trump?
Oh my God, I would pay such good money to know that, what their answer was before and after.
Yeah, I mean, if you knew, and I don't know. I mean, I guess they were asked maybe party identification, but I mean, that's the hard thing about this whole trial. We're dealing with a former and potential future president of the United States. And this is what we're talking. I mean, whether it was illegal or not, he's paying people off not to tell about him cheating on his wife. I mean,
yeah. Well, and that's the thing.
Give pause to people. It's not just a legal case. It does deal with the character of an individual that we are thinking about reelecting as president.
Right. And I think you make an excellent point, because the question is, if he's willing to cover that up, if he's going to involve, I mean, how many objections have we had and thoughts have we had about Hillary Clinton for how many years, right? Part of the objections to her becoming president was, what is she covering up? What crimes did she maybe commit, even if she was absolved? What about these email servers? And, it was so bad we wouldn't want that type of person, because we wouldn't trust them.
I can't imagine if it was reversed. Can you imagine what the headlines would look like if Hillary Clinton had cheated on her husband and paid off a male porn star? Can we think about what that would have played out like? And I don't think it would be like this.
He would have argued it. I mean, he already did. How much did he argue in the 2016 election about the crimes that she was alleged to have committed? And I think he didn't want it on the reverse.
The one that's the priciest is the illegal emails, and then you turn out that he's taking reams of boxes of classified documents with him.
Right, and that was the issue with the emails, is that it was classified and it was potentially leaked or available through not kept secret and classified. So yeah, I think it's, is it tit for tat? Is it what's good for the goose is good for the gander? And the other thing is, especially if we go back to what was relevant, what actually is relevant in this case, that I don't think anybody disagrees with, is why did he pay her off? Was it to silence her because of a possible affair and he didn't want his wife to know? Or was it because he didn't want it to influence the election? So by not having her talk, he then, influenced it because she wasn't speaking. He didn't want the story to come out before the election so people wouldn't hear it before the election. And did that then lead to the falsification of business records, which is ultimately what this case is about. So that's the question. Is the intent of Donald Trump in paying her off? Was it for election reasons? Was it for personal reasons? And can you genuinely say, well, it was only for Melania? Really? That's what the jurors have to decide. Is that credible? And if it's not credible, if they don't believe it's credible for him to say, I didn't do it, then I think it's more likely that they'll find any allegation that he says, any claim that he says credible. So if they're saying, okay, well, he says he didn't sleep with Stormy Daniels and he says that he didn't do anything to affect the election, I think one decision for or against Trump necessitates the other decision. That's my thoughts on it.
So let me ask one other question.
Yes.
It's bothering me as someone who's interested in the First Amendment.
Free speech.
The sleaziest thing that's come out in this trial is not Stormy Daniels. It's the notion that we have newscasters who are willing to pay money to hush a story up. And I want to know what the difference is between catch and kill and extortion. Now, I realize it's a different party, but
yeah,
if you didn't have catch and kill, the fact that there are entities willing to do that opens up the way for what I would consider to be extortion.
And the defense asked that of the one witness, the lawyer witness, who was part of arranging
that's right.
the payments.
I guess that there was an element where they asked that. And I'm not sure we got an answer, though. I mean, this gets to a question outside the trial in a sense, but it bothers me to think that we have news agencies or reputed news agencies that are willing to pay for people not to tell the truth. That really sticks in my craw.
It's very reminiscent of extortion and bribery.
Yes.
Right, I'm going to pay you off to do or not to do something. It's those people, the idea of the bribery most notably is paying judges, to swing one way or the other to make a specific decision. So you're right. How is this any different than paying somebody off to do or not to do something? And I think it is a little surprising that he wasn't charged with extortion because everybody thinks that that's what this is about, the hush money. That the hush money is the crime. But he wasn't charged with a crime related to the hush money. He was charged with a crime based on how he paid Michael Cohen off.
Right.
And added extraordinary interest. I wish I could be paid in that much interest.
And again, it's sort of the Al Capone phenomenon, right?
Yes.
You get a gangster and you get him for a tax evasion.
Yes. Very much so. But yeah, I am a little surprised. I think you've got a great point of why wasn't extortion charged? How is this a normal civil transaction versus a criminal transaction of bribery and extortion? So yeah. The bribery is
Although she's sort of the extortionist.
And that, you have a really good point, is she's the one going to them and saying, give me money or. Yeah. No, that's true. Then she would be the criminal.
Although in fairness to her, I think she actually wanted the story probably published.
Yeah.
She got her money and then they decided it's worth more to us not published than published.
Agreed.
Right. It's like the highest bidder, right? Like we can either publish it or we can't. Who's going to pay us more? Like, where is the benefit?
Yeah. And I mean, how many people sell their story to news agencies? That a lot of people do. I mean, all these prior
They have
murder.
a lot better luck than I have just selling my books.
Right. I don't have such an interesting story to sell, or I might. It seems to be good money. All right. So that's going to wrap up our review of Stormy Daniels' Stormy testimony on week 4. We do have more witnesses coming up. I am anxious to see whether Michael Cohen is our star witness for week number 5. I'm also interested to see whether Donald Trump continues to make noises and sounds and curse words and light, during the testimony. I'm also interested to see whether he will be making any other media postings and whether he will be brought to the judge again for making comments violating the gag orders. And will he testify? Now, we're not quite there. We're still on prosecution witnesses, but I think that is the biggest question of all, is will Trump testify? And will he? I think he's convinced that he can turn everything around. Chelsey, I think your point is well argued of he's a businessman who's convinced so many people of so many things by talking that maybe he thinks he can talk his way out of this. And maybe he can. A lot of people believe him. There are a lot of people on both sides. The country is divided politically.
No, I mean, I think
on his lines.
I think all of this happened. To be clear, I think all of this happened. I don't know if they can prove it, though. And I'm not someone who likes Trump. I really don't. But I don't know if they can prove their case. That's how I feel about it. Is it's one of these scenarios that I think it all happened. Can they prove it? I don't know.
I still think one of the most disgusting things about this trial is the comments that it's rigged against him, that the judge is a liar and unfair and whatever. Let's see what happens.
Right.
I mean, I do have some faith here. I mean, now, either way it came out, just based on what I know so far, I would say it sounds like they did their job. They paid attention. It's not maybe not what I would have come to, but I don't like people trashing an entire system because, of their situation, particularly when you're someone as well heeled and as well lawyered and as well prepared as somebody like Trump is.
Yeah.
I just,
And it's the first time. I agree. Wait till it's all done. Why say it's unfair or unjust when you haven't, maybe you're not going to be convicted. And I think I see this going either way. I honestly do. I wouldn't fault the jury for either decision, nor would I be upset by either decision. And that's me as an attorney, not me as anyone who, like you're saying, Chelsey, of regardless of my politics or my likes or dislikes in this particular trial, I think it's going fairly. And if anything, I think Trump is the one getting the short end of the stick with this attorney situation. Yeah. And I never thought I would be in the position for feeling sorry for him. But I'm actually found myself, as we've discussed in the podcast today, of feeling sorry for him, of, as a prior defense attorney, I just wanted to step in, and I've never wanted to be involved in any of these trials, nor do I still, but that lawyer part of me, that trial lawyer part of me that's so huge is like, oh my gosh, please don't do that. What are you thinking? I need to step in and do something. That poor man needs some help. Why would he, what a horrible situation he's in. And honestly, if I'm thinking that, it would probably best for him to win so that he doesn't have to worry about an appeal where it's ineffective assistance of counsel, because that only comes into play if he loses. So we'll see.
Again, he's going to have a hard time making that argument.
He is.
Particularly given that he's, I don't think any other attorneys would have spent that long on Stormy Daniels. They would have just, they could have asked 4 or 5 questions about what documents she had seen and not seen and who she talked to, and just sort of shrug your shoulders and say, we got a liar here. Why do we bother with her?
And honestly, I like what you're saying, because I think that probably would have been the most effective cross is not emphasize how big of a witness she was, not emphasize all of the details, but to make her irrelevant by your questions. You did this, you didn't do this, you didn't see any documents, you don't know about these payments, okay, thanks. And get her off the stand.
Yes.
That would have been so good. If it was a cross-examination that was like 4 questions of like, did you see this document? No. Do you know this? No. And then just that, and then dip, that would have been so effective.
Yeah.
So can I go back to ancient history?
Please go back.
Coaching mock trial, we would always rank. You would give a point score for each attorney and witness for each part.
Right.
And we had some people who wanted to give an automatic 0 to someone who did not conduct a cross-examination. And there were others who said that's exactly what they should have done.
It was brilliant.
They didn't need a cross. And I think we finally settled on a rule that you'd have to ask at least one question. But even there, some people said, no, a good attorney would just say, nothing to see here. We're not worried about this testimony. Call the next witness.
Yeah. Well, and that's a really good point. One of my best and favorite and most memorable trials was as a defense attorney. And it was a rape trial. So I've done, them on both sides. And I truly believe this person hadn't done it. And there was a DNA expert that the prosecution wanted to call. And it wasn't about identity. We admitted it from the very beginning. We said at the very beginning, yes, his DNA is going to be there. It's him. It's a question of consent, right? And that's the big question normally for rape trials. But I was like, it's a question of consent. Our theme was, he did it. It was immoral. You could even call it stupid, but it wasn't a crime. And what we did is we said, it's his DNA. We're not worried about it from the very beginning. And the prosecution called the DNA expert. And I objected, and I said in front of the jury, I said, Your Honor, we're willing to stipulate. We've already said in front of this jury that it's his DNA. We don't disagree. We don't need to hear from the witness. We're willing to stipulate that she's an expert and she found his DNA. They disagreed. The prosecution said, no, we have the right to put on our case the way that we want to put on our case. And the judge asked, are you sure? And they said yes. And for 45 minutes, they bored the jury to death, saying it was his DNA and here's how they did the testing, et cetera. And they said, Ms. Vile at the time, would you like to ask any cross-examination questions? And I said, no, we admit that that's him. Thank you. And it was the best thing I could have done. Yeah. And in the end, it was a series of events, but in the end, they found him not guilty. I think rightfully so. But I don't think that helped the prosecution. And in this way, I think you're absolutely right, Dr. Vile, I don't think this helped the defense by emphasizing her testimony instead of making her seem inconsequential.
Yeah, and that's what Trump says, right? It never happened.
Yeah. So why question it? Yeah. All right. Well, this was a fun one. I'm sure it wasn't fun for Donald Trump, and we wish everybody in the trial, well, especially good sleep. I can't imagine anyone's getting sleep at this time. It would be exhausting, but we're going to keep up on it because we're not that exhausted. Next week, stay tuned for week 5 of the Trump trial for the New York criminal fraud trial against Donald Trump. We will do that, and we'll also get another topic. If you're interested, we've also put out this week the topic about the campus protests. So we do have a podcast on the campus protests. It's hard to get everything when you're following the Trump trial, but other things are going on in the world. So campus protests, we've talked about that. If you want to find out what we think regarding the First Amendment and their freedoms of speech and assembly, check that podcast out. Otherwise, like and subscribe to the Law Unscripted channel so you can find us and continue to keep up with us, as well as get others to see the channel. I'm Virginia Tehrani. I'm joined by Chelsey Rogers and Dr. John Vile, and we're delighted to have this conversation today and look forward to week number 5 next time.